Well, we have three, but only one of
One
them.
for sure.
Your Honor,
Yes, ma'am.
we're ready when y'all are.
Okay, you want to go ahead and move that camera up? Keep going. One more. One more. I think you forget how tall. There you go, perfect. All right, we're on record, and this is cause number CR 24-232, State versus Michael Hegel. Mr. Hegel, are you going to hire an attorney to represent you in this matter? You have a motion
Yes,
to adjudicate. Who are you going to
Yes,
hire?
sir. Nolan White, my granddad has sent the check out, and Nolan is just waiting for the check to go through.
Okay. And you told me that last time, right? That your grandfather was hiring Mr. White for you?
Yes, sir. He just has to send the check from Washington State, so he's just waiting for it to get in and into process. Then he said he'll come and talk to me about everything.
Do you know when it's supposed to get to Mr. White?
My granddad sent it out on Monday, I think, Monday or Tuesday, and just waiting for that to go through.
Okay, I'm going to set you on the contested docket August 28th. Hopefully, Mr. White will get the check and he can get retained, and that'll give him some time to work on your case in the meantime, okay?
Yes, sir.
If that doesn't happen, then you need to notify somebody at the jail so that we can figure something out before then.
Yes, sir. Thank you, ma'am.
Thank you. Okay, Mr. Manning is ready.
I'll be such a bug yet, though. Hope that she will say that.
Who would you like first, Mr. Manning?
Judge, if we can pull Mr. Rosas.
Bernardo Daniel Rosas, CR 21-391. It's my understanding that there's an agreement between the state and defense. I believe the state has filed a motion to withdraw its motion to adjudicate and to continue Mr. Rosas on community supervision with 180 days in jail as a condition. Is that correct?
Judge, that, and he is going to participate in Collin County's intensive supervised probation and do that program in Collin County.
Is that a condition also
Yep.
here in Vincent County?
Yes, yes, Judge.
All right, Mr. Rosas, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Rosas, this agreement that you've entered into with the state, anyone threatened, forced, or pressured you to do that?
No, sir.
And are you pleased with Mr. Manning as your attorney and the work that he's done for you?
Yes, sir.
Do you have any questions about this agreement?
No,
Do you understand, Mr. Rosas, that this 180 days of jail time that you have to do you understand that should you be revoked at a later date and sentenced to prison, you will not get credit for any of those days that you're doing as a condition here during this amendment?
And Judge, if I may just clarify, he has credit for the 180 days. The dates for that are August 8th of 2023 to February 2nd of 2024.
Yeah, I'm aware that he has credit. I just want to make sure he understands that he will not receive credit should he receive a revocation order that sends him to prison. Do you understand that, Mr. Rosas?
Yes, sir. It's correct. Because, and 2027. Start 2 years from now and 2 years. Your term hasn't changed. Whatever you originally signed for.
Any questions, Mr. Rosas?
No, sir.
Okay, so you do understand that if you get another motion to revoke, and if this court hears it and determines that you violated the terms and conditions of your probation, if I revoke your community supervision in the future and I sentence you to prison, you will not get credit for these days that are outlined in that motion in order to withdraw. You understand that?
Yes, sir.
Okay, and do you still wish to go forward with the plea?
Uh, yes, sir.
Any questions? You seem like you're a little bit hesitant.
Well, no, just about I signed for 2 years initially. Is the 2 years beginning today or beginning from when I signed previously?
You're going to give me a moment to pull up your case.
Thank you.
All right, Mr. Rosas, can you see this order on the screen?
Yes, sir.
All right, so the court deferred a finding of guilt on May 2nd of 2024 and placed you on 3 years community supervision. The court has not modified that period of community supervision. So you're on probation until May 1st of 2027. That's not being changed. It's not being extended. You're just being continued on your original probationary period.
Thing is, I actually signed for 2 years. And I have the paperwork at home.
You have this paperwork right here that I signed that says that I think you're mistaken because it says finding of guilt deferred, 3 years, period of community supervision, 3 years. I think you're probably just mistaken. If you want me to show you more paperwork that you signed, I can.
Judge, I see that I was the attorney on that. However, I don't have my file with me with the original, the original judgment. I don't see any reason why they would not be the 3 years that was assessed at that point in time.
Are you able to see the red plate admonishments?
Judge, right now, all we see is the order of deferred.
It says 3 years here, $1,000 fine. That's
Judge,
just,
the only thing I think of is maybe he is conflating the exposure time, which was 2 years. That's the only thing I can think of, because it was a state jail felony.
potentially.
Correct.
Mr. Rosas, does that,
That's fine.
do you understand?
Yes, sir.
So the court has not modified your period of community supervision, which was 3 years from May 2nd of 2024. I've not extended that, done anything to that.
Okay.
The only thing that we're doing today is we're going to continue you on that original period, and you're going to be ordered to serve 180 days, to which you're going to have credit for. You're not serving an additional 180 days, but you're not going to get credit for that again should you be revoked and sentenced. And you're going to be amended to pay $500 towards the attorney fees that had to be incurred because this motion had to be filed on your case. You understand that? Okay. Understanding all of that, is that, do you wish the court to grant the state's motion in your agreement?
Yes, sir.
All right, and Mr. Manning, you've explained all of the rights and procedure to Mr. Rosas.
Yes, Judge, I've explained that we could have a hearing on this. The judge could sentence, the judge could sentence him up to 2 years, and that he is giving up a right to hearing on that in order to take this.
Okay, all right, then the court finds that Mr. Rosas, having the assistance of counsel, has entered into an agreement intentionally, knowingly, voluntarily. Court is granting the state's motion to withdraw its motion to adjudicate. The court will continue Mr. Rosas on community supervision, order him to pay $500 in attorney fees, order him to serve 180 days in jail as a condition of community supervision. The court will give him credit for time served on that. All right, Mr. Rosas, I would recommend this be your last time that you're on a motion in this court. Do you understand?
Yes, sir.
All right.
Thank you, Mr. Mayor.
Who's next, Mr. Mayor?
Judge, next we're gonna Miss Lena Price.
Ms. Price? Cause number CR 21-88, State versus Lena Marie Price. All right, looks like we have a similar agreement for Ms. Price. State's wanting to withdraw its motion to revoke, wants to continue Ms. Price on community supervision with placement on intensive supervision, and order her to pay an additional $500 in attorney fees as a condition due to the
Yes.
motion file. Is that correct?
Yes, Judge, and a slight difference between Mr. Rosas and Ms. Price's case. She was well on her way to doing what she needed to on probation, but through some family tragedy and some stuff going on, she just relapsed, and she recognizes that that's unacceptable since she's on felony probation. She's ready to tackle the ISP and get things straightened out and finish out strong.
All right, Ms. Price, raise your right hand. I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. All right, Lena, you and I, we've had a lot of hearings together through sanctions court and other. You understand that your rope is very short at this point.
Yes, sir.
I understand that addiction is a lifelong disease. I understand that relapse is a part of it, but you understand that relapsing while you're on felony probation, not a whole lot of grace to be given on that. You understand that?
Yes, sir.
So this is the time. This is going to be your last time.
Yes, sir.
I'm not going to put you back on and continue to have you doing drugs. If that's what we're going to do, I'll just revoke you. You'll go serve your sentence.
Yes, sir. No, I'm gonna stay clean, sir, and hit strong out there.
All right, court will grant the motion to withdraw. Court will continue Ms. Price on community supervision, places her on the intensive supervision program, and orders her to pay $500 towards attorney fees for the filing of the motion to revoke.
Judge, if we may proceed with the arraignment on Miss Nix. I don't have a copy of the indictment at this time.
Okay, give me just. Judge, Miss Nix's name is almost correct, but not quite. Her first name is Caitlyn. Other than that, she understands the charge against her as well as the range of punishment. Her plea is not guilty and request to be set on a pretrial docket. All right, the court finding that Ms. Nix has waived the formal requirements of arraignment, the court enters her plea of not guilty into the record, and the court will set her for pretrial hearing. How much time do you need, Mr. Manning? Do you want August 14th?
Judge, that should be good. In fact, Ms. Nix and I have gone over most of her discovery at this point in time, so I believe we should be able to get something figured out pretty soon.
All right, court sets Ms. Nix for pretrial August 14th. Are there any motions by the state?
Yes, Your Honor. State moves to amend and interlineate the indictment to reflect the proper spelling of Miss Nix's first name.
Any objections from the defense?
No objection from the defense.
All right, court grants the state's oral motion to amend the indictment to correct the spelling of Miss Nix's first name, Caitlyn, Caitlin, no Y. Court will make that amendment onto the indictment this date. Who's next?
Judge, next, we're ready on Mr. English.
Cause number CR 25-21, State of Texas versus Douglas Heath English for docket call.
And Judge, if I may, he was just brought in. I have one question to talk to him about. Judge, as you may recall, on Mr. English's case, we were waiting on a DWI third or more that was he was arrested on. At this time, the state has, my understanding is the state has still not indicted that case, and so we're going to request a agreed PR bond for the DWI third or more, and we will announce ready on the assault cause family member, household member with previous conviction, asked for a trial setting in that case.
And Your Honor, that's correct. The DWI third has been under attorney review, has not yet been presented to the grand jury. I believe the 90 days is up tomorrow or Saturday. So obviously we don't have a grand jury setting before then. So state would concede that Mr. English is entitled to a PR bond on the DWI third.
Okay, so either a writ will have to be filed or you'll have to contact the justice of the peace who did the magistration. I don't have jurisdiction over it if it's not filed.
Judge, what I can do is I can file an agreed order under the writ, under a writ number. And my understanding is that the clerks can get that file where it needs to go.
Yeah, if you file the writ, that will invoke my jurisdiction and then I will review it.
Thank you, Judge.
All right, and so Mr. English is, you said rejecting all offers at this point?
That's correct, Judge.
And Mr. Hartwell, is there an offer that was provided to Mr. English?
I believe there was, Your Honor, if I could have just a moment to look it up.
Do you know what it was, Mr. Manning, off the top of your head?
Judge, we had been discussing the assault case prior to his picking up the new offense. And at that point in time, Mr. English maintained his innocence and was requesting a jury's selection. I know the state made a combined offer, which was a significant amount of prison time. And that was the most recent offer that we rejected.
That's correct, Your Honor. The state's offer was for a global resolution for 15 years TDCJ.
Was there a different offer made, not considering the unindicted DWI?
No, Your Honor. I believe the only offer that went out was the global resolution.
Okay. All right, court will place Mr. English on the court's trial docket beginning August 4th. And once he reaches the top 10, Mr. Manning, you'll be notified.
Thank you, Judge. Judge, next ready on Mr. Hardy. Oh, I'm sorry. Hold on. Judge, we are waiting on one thing. I guess we can do, if I may have a moment to speak to Mr. Johnson. He had a question before we announce on his case.
Yes, sir. Go ahead.
Thank you.
All right, you said this is Mr. Johnson?
That's correct, Judge.
This is cause number CR 25-44 and 45, State versus Henry Daniel Johnson. Docket call. Go ahead, Mr. Manning.
Judge, after extensive discussion with my client as well as reviewing the discovery, he maintains his innocence and requests a jury trial before a jury of his peers.
All right, and Mr. Hartwell, what any offers made to Mr. Johnson? I understand that he's rejecting all offers, but I want to know if any offers were made.
Yes, Your Honor. In this case, we're still waiting on the report from a phone dump. Because I hadn't yet had a chance to review that, no offer was made, as that could significantly impact what offer I would extend, depending on what is involved in that.
Okay. All right, court will place Mr. Johnson then on the court's jury selection docket beginning August 4th. And state and defense will be notified if Mr. Johnson ends up in the top 10. Is this a case that should be considered for special setting?
Yes, Judge.
State would request that, Your Honor, as there is a child victim and the potential for multiple experts that may need to be called for either side.
We're not going to set it today, but I will consider it.
Thank you, Your Honor.
Judge, ready on Mr. Hardy?
Court call State of Texas versus Mark Anthony Hardy, CR 25-77, CR 25-90. Mr. Hardy, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you, sir. You can lower your name is Mark Anthony Hardy, is that correct?
Yes, sir.
And Mr. Hardy, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, I am.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you have any questions about anything that you have read and signed today?
No, sir.
Do you have questions about anything else before we proceed further?
No, sir.
All right, it appears that you have been charged by indictment in cause number CR 2590 with fraudulent use or possession of identifying information or identifying informational items between 5 and 10. Third degree felony does carry a range of punishment of not less than 2 years or more than 10 years in prison and a fine not to exceed $10,000. I see the plea agreement you've reached with the state is upon you pleading guilty. The state's recommending that the court assess your punishment at 8 years confinement in prison, with that prison sentence being suspended and you being placed on 5 years of community supervision. Also, as a condition of that community supervision, you would be placed on the intensive supervision program. There would be zero fine, but you would have court costs of $290 and reimbursement fees of $520. And it appears that the state is also asking the court to dismiss under section 1245, cause number 2025-195, which appears to be a misdemeanor burglary of a vehicle, and also cause number CR 25-77, which is engaging in organized criminal activity. Mr. Hardy, is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
Mr. Manning, do you believe Mr. Hardy to be competent today to enter into this agreement, that he's doing so intentionally, knowingly, and voluntarily?
Do believe he is competent and that he is entering into this plea intentionally, knowingly, and voluntarily.
Mr. Hardy, how do you plead to fraudulent use or possession of identifying information?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the evidence?
No objection as offered.
Evidence is admitted, court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with all victim services restitution paperwork was sent out and none was returned to the state.
Thank you, Mr. Harwell. Anything further from the defense?
Rest in closed, Judge.
All right, court will consider the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement. The court convicts Mark Anthony Hardy of fraudulent use or possession of identifying information between 5 and 10. The court, finding that this is a third-degree felony, assesses punishment at 8 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today and places the defendant on 5 years of community supervision. Court orders him to be placed on the intensive supervision program as a condition of probation. The court orders Mr. Hardy to pay $290 in court costs and $520 in reimbursement fees. Mr. Hardy, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. The court this day is also dismissing under section 1245, cause number 2025-195 and CR 25-77. Mr. Hardy, please step over with the bailiff to be fingerprinted. After that, you'll get more information from the probation officers.
Judge, I believe that concludes my business. I'll be excused.
We need to set Mr. Park's case. Cause number CR 22-192, State versus Joseph Leon Parks, motion to adjudicate or revoke. We have him confirmed in custody in the Hutchins unit. Do we know, is that Ms. Taperham, is Mr. Parks down there on a prison sentence? Is that what he's in there for?
Yes, sir.
Okay. And I think I had it marked today for status of prosecution. Mr. Hartwell, do you have any information?
Yes, Your Honor. I know we've had some trouble getting bench warrants in the past. I believe the county he was being held in was not honoring those. Your Honor, state would request a bench warrant to get him wrapped up at this point. I think it'll be a one hearing issue, but we would like to get him wrapped up.
Was he the one that was he sentenced and sent as TDC before we get him bench warranted? Was he one of those?
I think he was, Your Honor.
All right, court will issue a bench warrant for Mr. Parks at the Hutchins unit. And we will set Mr. Hutchins then on the contested docket August 28th. All right, Mr. Manning, I think that does conclude you today. Yes, sir, you are dismissed. Thank you, sir. Appreciate your work.
Thank you, Judge. Yep, real quick.
Ms. Tabraham, do you have anyone else there that needs attending to?
No, Your Honor.
Okay.
All right, that having concluded the court's criminal docket, we are adjourned for the day.
Thank you,
Thank you,
sir.
Mr. Hartwell. Thank you, Mr. Hernandez.
Thank you, sir.
You're welcome.
Thank you, Your Honor. Bye-bye.